Okay. All right. Well, yeah. So I want to welcome everybody to our March DAMA Philadelphia chapter meeting. And to everybody that's here and to everybody listening in at home, off hours, and catching up on the latest privacy legislation, which is our topic for today. I wanted to just give a brief overview for anybody that is tuning in for the first time or joining us live this morning for the first time. We are a chapter of DAMA International. It's over 50 chapters around the world, and ours being one of the older ones, I believe, founded in 1993. And we've been having these meetings about every other month. So you can expect one September, November, January, March, and May. And there may be a summer certification focused event as well in certain years. And the topics generally range from data governance, data stewardship, data quality, analytics. It's it's a pretty good dive into, occasionally we'll include enterprise architecture, some soft skills, and a lot of, some of the benefits and what attracted me and a lot of people I think here. A lot of companies are represented in the Philadelphia area. It's a great chance to connect with people in those other organizations to see how they solve some of the same problems we try, to solve in our own professional world, and also just to build those lasting professional relationships over the years and support each other's professional development. We have speakers that come in, both local, regional, and national, that fly in, and some of the prominent names that you might sometimes see at the national conference, the Enterprise Data World Conference. So it's been attracting. If you started back about 10 years ago, our meetings were generally about 40, 50 people. Pre-pandemic, in the last couple of years, we've doubled that. We've had events close to 80, 90 people, 100 people. We've had to increase our space. So it's really, the importance of data has really taken on a new meaning. And I think, it's competitive advantage, and it's also some of the regulation has been coming out, like the ones talked about today. So that's who we are. That's what we do. I wanted to very quickly just give a flavor of, let's see, our next meeting is in May, and that's going to be around analytics and innovation. And Elation is a sponsor of that meeting, and actually, and John is on the call. So thank you. That's something to look forward to. John, if you wanted to just say anything real quick, not to put you on the spot or anything, but thank you for
having some video issues this morning, so I apologize.
Right.
Really looking forward to talking about balancing innovation and analytics with governance. A lot of folks working on what I would call like practical self-service measures right now. Elation's a data catalog, but we'll stay high level with the topic in general around how to do that.
Great, thank you. Yeah, that's that, and we have a couple of other prospective speakers for that as well. So that should be a good event to round out our academic year. The meetings kind of circulate around on the September through May. And then as far as the other thing that happens in May is our election process. So I wanted to have Ray, our past president, give a overview of the positions. And I will add that due to some tragic circumstances, the president position will also be available. It's not normally an odd year position, but it is an interim service that I'm performing. And if anybody that is a former or current board member, those are the eligibility requirements, is interested in the president role specifically, please let either Ray or I know. It is not, something that, I will contest if there is interest. It's something that we can pass the baton. So please consider that in addition to the positions Ray is about to mention. So Ray.
Excuse me. Hi. Yeah, I think I have held the position of past president longer than almost anybody else in any organization for that matter. And one of the things, we are one of the oldest and probably one of the most active chapters in DAMA International. We've had people who have spoken at both the Philadelphia and, for example, New York chapter, and they came here thinking that we'd be smaller than New York, and they were amazed at how much larger we are in terms of meeting turnout and activity. And a lot of that has to do with the quality of the board. We've been very lucky from the beginning to have had an engaged board. I think the couple of reasons behind that include the fact that we have, a reasonable amount of churn on the board. In other words, we don't have the same people in the same positions for years after years. Some chapters have actually had the same president for, 15, 20 years, which, you end up with not getting new ideas. So we have, like I say, a reasonable amount of churn. The way the board is structured, we have 10 positions, 10 vice presidents. And then we have, in addition to vice presidents, we also have associate vice presidents, so that, we can spread the work out. And if somebody is interested in considering a board position, but isn't, quite ready to step up to the plate, we encourage them to, volunteer to be an associate vice president for a term, and then get a feeling for what needs to be done and move up from there. So I will be publishing the list of open positions, but I'll go through them now. This is the odd years. So the positions that are open is communications, which is primarily also, used to be called the board secretary. Getting the minutes out, keeping the documentation, and so on and so forth. Corporate sponsorship. We've been lucky when we've had, in-person meetings, which can get, a little expensive with the, sometimes if we have to pay for a room, paying for breakfast and lunch. So corporate sponsorship reaches out to corporations, and it's really, we've had a lot of interest in the past. Corporations are interested in, being able to meet our members and explain what they do. Programs is, a very important position. That's the VP who gets us our speakers. And as Eugene mentioned, we get speakers that are known, not just, regionally, but internationally as well. And sometimes a couple of chapters will get together to spread the costs if we're bringing somebody in from afar. Online services. So if you go to our website and get the information from there, that's important in these days, of course. And then membership services, making sure that we keep the membership list up to date so that we can broadcast what we want. Provide discounts for things like the enterprise data world. So those are the 5 positions that are open. We'll be taking nominations up until just before the meeting in May. And I like I say, I'll be sending out some emails so that we can get the interest. But feel free to if you have any questions, to contact myself or Eugene. And thanks, Eugene.
Yeah, thanks, Ray. And those positions are all pretty key to getting the kind, keeping the kind of cadence we've been able to sustain. So we do have 3 speakers today. Actually, bonus. Usually for these half-day sessions we have 2, and all on the topic of data privacy legislation. We have joining us after this will be Donata Skillard with the termageddon, and then rounding out the day will be Sanjeev Upadhyay with the DAMA India. And but first, I wanted to welcome Peter Carr. Peter Carr is a principal with Captech Consulting, and fellow alumni.
Yeah. Wow.
And certified data management professional, certified business intelligence professional, and other certifications. I'm not even sure I'm actually familiar with all of them. And I think Captech's pretty strong down there in Virginia, and Virginia is one of the states that's pushing the latest privacy legislation. So Peter, I will let you take that. Thank you for joining us.
Sure. Do you want me to share my screen with the slides? I need to.
Yes. Let me see how I can make you a co-host. Right. Yeah.
There we go. Yep. There we go. It's working. Let me know when you can see my slide.
Yep.
All right. Let's try to get a full screen here if I can. There we go. Hey. Okay. I got the thumbs up from Greg. Well, thank you, Eugene, and thank you to DAMA Philadelphia. I am going to try to make this a little interactive. I know that's challenging in this kind of environment, but I certainly would love to hear some feedback, and I'll have some questions in the presentation. I want to just echo what you said earlier, Ray, about DAMA Philadelphia. It is a large chapter. I'm involved in the Richmond, Virginia chapter of DAMA. Peter Aiken is our president. And I would have to say that every time I've come to DAMA Philadelphia, and I've come probably 3 or 4 times over the last 5 or 6 years, I've been so impressed with the content and the quality of the presentations and the number of people that are involved. I think it's a testament to a well-run organization. So it's an honor for me to get to speak again to the DAMA Philadelphia group about a subject that is becoming near and dear to my heart, that is data privacy. Let me just tell you a little bit about myself and about Captech just to start. I am a principal at Captech Consulting, as Eugene said. Captech is a full service consulting company. We have over 1,000 employees across the country and 11 regional offices. And Philadelphia is one of the first cities that we expanded to over a decade ago from our Richmond, Virginia roots. Our company has a 25-year history of delivering technology solutions to our customers. And I started the data and analytics practice or division at Captech in 2005. And I'm proud to say data solutions has become one of the leading revenue generators at Captech. So today I don't actually run the data and analytics group anymore. I've handed the reins off to somebody else. As Ray also mentioned, sometimes new leadership also brings fresh perspectives. And so it was my pleasure to hand off the running of the operation a few years back. And today I spend my days running client projects like the one I just completed in February for one of the leading healthcare providers in the city of brotherly love. So yes, I actually got to spend some time with somebody else on this call that was the project manager on that effort. So I love doing that kind of work as well as thought leadership and getting to spend time teaching. I teach at schools like the University of Virginia and the College of William and Mary. And I teach on a range of subjects from data governance, data privacy, data management to data quality. So a lot of the areas that is centered around what DAMA focuses in. I regularly meet with clients and prospective clients, vendors, and industry analysts to discuss current business challenges as well as approaches to solving these challenges. And my core skills as well as the things I mentioned that I teach about and data privacy. I do hold a CIPM and a CIPT certification. Those are actually fairly involved. And I understand there's probably a speaker coming up that's going to talk a little more about, I think, the CIPP exam, which is even a level above. So kudos for those folks that have those type of certifications. Prior to joining captech, I worked at companies like McKinsey and Company. I worked for Mobil, now ExxonMobil, Informatica, Northrop Grumman Information Technology, and I also co-founded a China-based startup company that operated in Shanghai, China in the late 90s. And actually, I think my first real exposure to understanding what privacy was when I lived in China, and having every aspect of your life monitored and watched by the government gives you a really different perspective on what privacy is all about. Again, as Eugene mentioned, I'm a double WHO. Went to the University of Virginia, I have a BS in Commerce and an MS in Management Information Technology from the University of Virginia's McIntire School of Commerce. When I consider my background, and I think about the days that I had in China, I do think privacy is something that we should value. And I think for too long, consumers have taken that for granted. And I'm glad to see that people are taking it more seriously now. I remember back in 2018, the thing that began captech's journey in privacy was a phone call I received from a former student of mine at UVA. He was an executive at Capital One, had left Capital One and gone to CarMax, and he asked me if I could come and talk to him about Ccpra, if I knew anything about it. And this is in 2018. And at that point, I had done some projects with GDPR for some of our international clients, but I hadn't really done much with Ccpra. So like a good consultant, I said, well, let me get back to you in a couple of days. And I, of course, went out and learned as much as I could about the California Consumer Privacy Act. And then I went and met with John and some of his colleagues, and we just had an open discussion about aspects of privacy. And this began captech and my journey into privacy. And it really kind of opened my eyes up to some of the things that we were taking for granted as consumers, and some of the things that we needed to focus on. So I'm really glad to get to talk about this topic and be here. And let me ask you a starting question. How many people have heard of or know who Alistair McTaggart is? Does anyone know who he is?
I do not.
No? Anyone know? Well, Alistair McTaggart is the person in California who initially he's a real estate mogul, but he thought this privacy issue was important enough to bring it up as a ballot initiative. So back in 2017, 2018, he decided to make a ballot initiative and put it on the California election cycle. Or it was threatening to put this ballot initiative to give consumers new rights. And the legislature in California got a little nervous because the ballot initiative was going to be pretty damaging to businesses in California. So the legislature said, let us, instead of making it a ballot initiative that the voters would vote on, let us create a law and pass a law. And Alistair said, well, if you make a law, that's fine. I think that would be appropriate. And so the legislature rushed to put this law in place in 2018. They voted and put this law in place, the California Consumer Privacy Act. And it was the most sweeping privacy law to date in the United States. It was on the heels of GDPR, which passed in 2016, I believe, in Europe. And that was the European law equivalent. And Alistair was just somebody that is well thought of in the area of privacy, because he kind of prompted this whole wave of privacy law in California, again being the first one. Now, does anyone know who Dr. Ann Cavokian is? No one jumping out there? I have a quote of hers here. She is widely attributed to have begun what we call privacy by design, and the principles of privacy by design. She came out of Canada and was a former information and privacy commissioner for the Canadian province of Ontario. And her concept of privacy by design takes privacy into account throughout the system engineering process. And it's become sort of the standard in building privacy into our applications and systems in today. And so as we evolve our privacy capabilities, technologists, like many of us that are on this call, need to be thinking about how do we introduce privacy into everything we build. And that's really kind of where privacy is moving to. Right now, I think the industries are in a state of reactive mode. Let's react to these privacy laws. But privacy is something. While the laws are new, we've had data breach laws since early 2000s, and those data breach laws taught us that not having proper security measures for organizations around personal information can bring about pretty heavy fines. And those breach laws that swept across the country in the 2000s were kind of the first wave of, hey, we need to be aware that if our company collects or stores personal information, we need to protect it. But what California's law did is it took sort of the data breach law, which it basically said if private information that you are storing is disclosed, you have an obligation to make it right with the consumer. What California did is it redefined what personal information was. So generally speaking, and I'm actually on slide 3, as you can see here, generally speaking, data privacy statutes protect the privacy rights of individuals. They provide guidelines for collecting, storing, processing, sharing, and deletion of personal data, and they describe penalties for noncompliance. But California's law, as I mentioned, redefined what personal information is. It's no longer just your name, your address, your phone number, your social security number, things that we used to commonly think of as personal information. They made a much wider description. They had 32 categories of data that were now considered personal information. Everything from your educational background, the fact that I went to UVA and graduated, to my employment background, to even inferences that companies draw from looking at your behavior on the web or your social media behavior. Those inferences that the company derives about you is actually personal information that these privacy laws are saying are in your domain, that you now own. So specifically what these privacy laws, both Virginia's, California's, Europe's law, is they limit the amount of personally identifiable information that companies can collect. So GDPR, the European law, Ccpra, the California law, CDPA, the Virginia law, all limit the amount of PI data that can be collected for the purpose under which it's being used. These laws also require that companies that collect PI data must send the consumer's PI data if the consumer makes that request. If the consumer requests that a company deletes their personal information, the organization has an obligation under these laws to comply with that request. Furthermore, the consumer can request that you cease selling or sharing personal information about them with third parties. And this has a pretty massive impact on organizations that use third-party services to process data, whether it's collecting or getting inferences about people, or trying to do value-add services for your consumers with third parties. If you share that data, that it comes under some restrictions according to these laws. And I'll get into some of the specifics about that. I like to geek out on this, so you'll have to bear with me. And if I get too ingrained, you can holler, please stop. But that's what I want to share with you today. Another specific of the law is they provide opt-out options for targeted marketing. So this is what's new in the Virginia law that wasn't really spelled out in any of the other laws, that you can opt out of simply targeted marketing. They also have an opt-out of sale, which was common in the other laws, but opt out of targeted marketing, which is going to be interesting on how companies are going to comply with this. So this is a new regulation that CDPA, the Virginia law, put out there. And furthermore, they all have this opt-in requirement for somebody designated as a child, and the different states designate a child differently, interestingly enough. 16 is the designated age, 16 or under for California. In Virginia, it's 13 or under. So if you think about that, Virginia actually lowered the opt-in for children to 13, which means that if you're a 14, 15, or 16-year-old, you're essentially treated as an adult in Virginia. Why might you do this? Virginia's law, as we'll talk about later, is much more business friendly than California's law. And if you think about organizations that might market or send information to high schoolers, let's say, like high school letter jackets or high school rings or things like that, that might have children as the target, they're not required. They don't require an opt-in by the parent for marketing to those children in Virginia. However, that is the requirement up to 16 in California. And then the last one I have here is you have to consent to process personal data. So this is a hallmark of GDPR that consumers must consent to the processing of their personal data. These laws also specifically give consumers the right to private action. At least the California law does. Now, this is not the case in Virginia, but what does that mean? That means that consumers can actually sue companies that do not comply with these laws. So that creates a huge burden on organizations. Now, it's true that the California law stipulated a fairly small sum of money for that private action. They can $7,500, I think, is the maximum penalty. I think each fine is $750. However, companies don't want to be mired in lawsuits from consumers, not to mention the optics of something like that taking place. So, right to private action actually has a lot of is a little more powerful, despite the limits on the amount of money that can be recouped for violations. And the law describes penalties for non-compliance. So what the limits are, all of the laws have that. It's just the right to private action is only part of California's law. Virginia's law designates the authority to go after companies to the Attorney General of Virginia. Furthermore, Virginia has actually set up a separate law that's going to provide monetary support for the AG's office, the Attorney General's office, and it will basically be a bucket where the fines will get collected and then used to further pursue legal action if that's necessary. Virginia is a little different than California in the way it works. So the legislature in Virginia is a part-time legislature. It only meets the first 2 months of the year and then is off for the rest of the year. So most of the legislation, the senators and House representatives in Virginia all have full-time jobs. But what this means is, unlike in California, where there were a lot of changes to the law after the law passed in 2018 before it went into effect in 2020, in Virginia, there's not going to be much of an option to modify the law. You're not going to see huge changes. So essentially, how the law is written in Virginia is how we're going to see it play out when it goes into effect in January 1 of 2023. So companies have about a two-year lead time to get prepared and set up their systems. I'm going to take a pause. Any questions so far? Okay, hearing none, I'm going to move on. So let's
Good
talk
stuff, Pete.
about.
I'll
Yeah.
give you good stuff, Pete. That's what I'll give you. Good stuff so far.
Good
So
stuff.
you know that we're paying attention. Thank you.
fellow geeking out on privacy law. I love it, George. Thank you. All right. So Virginia's new Consumer Data Privacy Act. It provides to consumers the right to know if and what personal data is being collected, processed, or sold by organizations that are capturing personal information. Individuals also have the right to correct inaccurate personal data. Now, this is unique to Virginia. It is not in the California law. So a new capability companies that might have gotten prepared or might have set up for the California law are going to have to modify, is they're going to have an ability to correct personal information. Now, most people think, well, you would want to correct somebody's personal information if it's wrong. Like, for instance, if somebody gets married and changes their name and they want to have a new name, of course, companies are going to want to have that corrected in their system so they can properly send that individual information. But it is now a right of the consumer to make companies change inaccurate personal data. And I think this is going to be more consequential than we think, because clearly, things like name changes or address changes make a lot of sense. But if you broaden this out, like if people or companies keep a record of my educational background or the companies I've worked at, and they don't have a full list or it's incorrect, I can actually reach out to them and make sure they correct that or change that. And I think this is going to be a little more challenging for companies to do than we think. But that is a new right that is in the Virginia law. Virginia also has the right to request controllers delete their personal data. Again, this is similar to California. And the right to restrict processing of personal data for targeted marketing, a new specific restriction for Virginia. And then the right to restrict processing of personal data if the data is being used differently than the purpose for which the data was collected, or if the use is not consistent with the purpose it was disclosed to be used for. So if a company says, we're collecting your information to add you to our frequent buyer program, but then you get some kind of marketing that is unrelated to the frequent buyer program, you can call and tell them that they're in violation, that they need to stop sending you that type of information. They must comply. That's a piece of that. What organizations are subject to the new Virginia law? Well, this slide might look familiar, like similar to the California law, but it actually is a fair bit different. And I want to get into some of the differences. So basically, companies that process over 100,000 Virginians' data are subject to this law. So if a company collects and processes 100,000 citizens of Virginia, then they are going to be subject to this law. Or if they process 25,000 unique Virginians and have 50% of their gross revenue derived from selling Virginia's personal data. Now, this is different. It's similar but different to California's law, and it's much more business friendly. Let me note that there is an absence in this particular scenario of a revenue threshold imposing the obligation. In California, they said, if your company earns more than 25 million or has more than $25 million in revenue, regardless of whether your business is working with consumers, you have to oblige or comply with this law. And so that was impacting companies that were B2B companies that that had some consumer data, but not a lot, but were over 25 million. So there was this blanket regulation that had to be complied to, even if your primary business wasn't dealing with consumer data, collecting or processing it. If you had over 25 million in California, you had to comply with this law. Virginia does not make this blanket stipulation. So this is going to be an advantage to large B2B companies, business to business companies that don't process more than 100,000 records of Virginia's data. Plus, Virginia's law doubles the amount of the Virginia consumers that a company can process. So California's limit was 50,000. Virginia's upped that to 100,000. I don't know if that's a huge thing, but there are a lot of Virginians, so I don't know how big a thing that will be. But some people say that that also, again, leans towards being a little more business-friendly law. The law also explicitly omits persons from the definition where they're acting out of commercial or employment context. So what this means is that definitely B2B, if you're collecting consumer data of a consumer because of a B2B relationship, that's excluded in this. And in California, they also had a provision that wasn't actually enacted in the beginning of 2020 about employees and employment data, so that companies had to respond to employees who requested their personal information. Virginia does not have that language. It actually is explicitly taken out. Those are exempt, so it's not going to cover employee data, which again is going to be a little more friendly to the businesses that are operating. This is a quick look at the rights between Virginia, the California law on the top line, and Virginia law on the bottom line. I think it's important to note that in November of this past year at the election, California's approved another law called Ccpra, or CPRA, California Privacy Rights Act, that's going to usurp CCPA. It's going to replace CCPA, and it's going to replace it in January 23, just like the Virginia law. And it's much more, it's actually more wide sweeping than CCPA. So more to come on those changes, but that's going to impact companies that were set up their organization to reply to the original CCPA. Now they're going to have to modify for CPRA. But let me just talk a little bit about a couple of the differences. You see the double asterisk on the Virginia law for opt-out of sale of PI of personal information. California's law defines the sale of personal information as the exchange of personal data for monetary or other valuable considerations. And it's that last part, the other valuable considerations, that created a large problem for organizations that were sharing data to third-party vendors to do processing of a person's information for one reason or another. Like maybe they're running a marketing campaign, so they provide that information. Because some companies set up subsidiaries or third parties that they don't actually pay for the individual's data. They have a different type of remuneration for the agreement. And so the California law used this other valuable consideration to say you're not exempt from this law. However, Virginia's law just says for monetary considerations by the controller to the third party. So if it's not for monetary reasons, that means Virginia companies that have subsidiaries or have these third-party processing companies, they might be able to still use those and share PI data with them. And they might be exempt because they're not paying, the third party is not paying monetary money for that data. Does that make sense? It's a little nuance, but it's an important difference. Let me talk a little bit about this risk assessment, the last item on this list. Virginia added this. This is new, and this is, again, more reaching than California's law. Much like the GDPR or the European rules that required what we call PIAs, privacy impact assessments, being done on systems of European companies that process data, Virginia created a requirement for companies to do risk assessments. So what it says is it requires controllers to conduct data protection assessments that evaluate the risks associated with processing activities, while the Act specifies the types of activities that must be assessed. It fails to indicate how often they must occur or how long they must be kept. So even though Virginia added this risk assessment, it's a little unclear, how frequently this needs to be done, but it's clear that it must be done when you're dealing with risk-based information. So I see some chats here. Let me I don't know if I can do that. All right. Got sidetracked with the chats here. Can somebody else read? I don't know if
There was
chats.
there was a couple of, there's the one question is, there seems to be a lot of state level, and some, different, as you're going over the differences right now, are you expecting some sort of a federal standard eventually to emerge, or will it continue to be at the legislative discretion of?
Great question. I'll hold that question for another slide, but yeah.
And then on the topic of correcting data, I had one about, well, in data warehousing we have facts and dimensions, and the facts are time stamped, and so a dimension can be, we have type 2, dimensions change. So somebody's address and somebody's maiden name and married name, well, at this order it was this, and the next, other, correct. When we have a request for correction, are we going back in time and correcting things that at that particular, in 2013, that was the correct address, that was the correct name?
Yeah, no, a fantastic question. Somebody that clearly understands data management. And so let me just use this as an opportunity to put a caveat. I am not a lawyer and I don't pretend to be one, so I cannot provide legal guidance to anyone. So anything I'm saying here is my opinion. But I would say that, obviously if you have time stamp or effective dating, or you use slowly change dimensions where you have people's address for the last 7 years or something like that, and you're showing address changes, the change would clearly stipulate that, in my opinion, the change is clearly going to talk about what you're currently using, right? So if you had a business need to have the legacy addresses, then I think by all means that would be appropriate. Again, you would have to, have a business need for that information. But if you did, and that you got a request to correct, you would only have to correct the current. Now, if they requested you delete the data, you'd have to delete it all, right? So that's actually very clear. So even if it's a legacy address, it can individually tie back to an individual, because you have the time that person was living at that address by your effective dating. So therefore, it could individually identify an individual, which is the definition of personally identifiable information. So if they requested you delete that, you'd have to delete it all. If they request you correct, you'd really just have to correct the current state. So great question. Any others?
So yeah, Pete, along those lines, so I mean, that kind of implies that you actually have to show the person their current record, right? So so they have to have that interaction, right?
Well, if the consumer makes the request, this access and portability option, the first column in there, if they make a request for the data, you have to provide all the addresses, right? So you, not just one, you have to show them you have 7 of their addresses and 5 of their different names and their pseudonyms. So, and yeah, so if they make that request, if the consumer makes that request, the business has the obligation to provide that to them. They can then look at that data and go, holy cow, I can't believe you have all this information. I mean, I want you to delete it all, right? In which case you would have to comply as an organization if they say, well, you just have my wrong current address and change that. But you're right. I mean, that was one of the things, in some of the work we did with some of our clients, one of the things they realized is, hey, if a consumer learns how much information we have about them, they're not going to be happy with us. So a lot of companies actually at last year or 2019 took the opportunity to clean up a lot of the legacy data. And I thought that was a great move. A lot of, we're going to talk a little later about turning this to a competitive advantage. One of the reasons dealing with privacy law can be a competitive advantage is because you can erase a lot of data you no longer need to have. That just adds risk to your organization to have legacy PI data that can be stolen or misappropriated or lost. And if that happens, your company's liable. So why not get rid of it? So we talked a lot of our customers into deleting a lot of PI data because they just, they recognized this was going to be a huge risk at their reputation if this information made it to the consumer's hands. So they took 2019 as an opportunity to delete all that data so that they didn't necessarily, when a consumer asked in 2020 to see their data, they didn't have all of that data on the books. So that was a good move, I think.
Okay. Thanks, Pete. Yeah, just one following question though. So are other state organizations and or federal organizations responsible for following these laws as well?
So are others?
So like Virginia State, would Virginia State be required to make sure they?
Yeah, there are exemptions, and I'll actually get into some of the exemptions. No, I mean, state and federal law, they wouldn't be subject to this because they're not a business, but there are other exceptions too to this. So I certainly want to get to those. So what do organizations need to do to get ready for Virginia? Let's say you haven't done any work with privacy. What are the current sort of basic steps? So the first step is typically identifying where personal information lives in your organization, all the systems, taking a full inventory. If you've got good data management, good metadata, good master data management, you might have a pretty good idea of where all your consumer PI data lives, but you need to look at the definition of PI data, because a lot of companies found that, hey, we never considered, our model scores to be personal information. But if you read the definition of personal information according to California, and by the way, that same definition is in Virginia's law, then we have to consider other data personal information. So you have to get a complete inventory of the list. You have to understand how it flows through the organization, look at all the systems. Typically what happens is you have some core systems that collect data, and then that data gets replicated and shared. Think about your marketing data. You might collect it on a website, but then it gets shared to your marketing campaign software, your ad tech software, or your advertising software. And so that data, that personal information, gets replicated into many companies. So you have to follow where that data goes, how it gets updated, how it gets deleted. So the CRUD aspect of it. Then you want to inform your consumers. You have to have notifications on your websites. You have to have a do not sell button. You have to have your privacy notifications. And all of us have probably seen these either in our organizations or in companies we do business with online. You see these plethora of privacy notices and consents. There's cookie consent now that's out there, and these are all forms of informing the consumer. Then we have to, as an organization, establish processes to meet those rights requests. So if a consumer makes a request, how am I going to go get all that data and send it to them? And what's that process look like? Do I have a website stood up for consumers to make requests, or do I get a letter from them? And then how does that letter get properly managed and routed? Because I have only 45 days to reply to this request. So those rights requests and fulfillment processes have to be established. Then you get into your third-party management. You have to modify contracts with third parties to make sure they're managing personal information properly. So if personal information is sold to third parties in Virginia, you need to make sure those contracts stipulate that they'll have the same protections and guidelines on their data. And if a consumer makes that request to delete, you as a company that have used a third party and provided that PI data, you have to make that third party delete that data, right? So that's part of it. And you have to modify your contracts to make sure that happens. We had a call center at one of my companies that used a third party call center. And they, of course, had to share all the PI data with that third party because that third party took calls on their behalf. Well, when a customer made a request to delete it, what we found out is that third party had a complete other data warehouse that they kept on these customers, that they pulled up these data. When people call in, they pull up the number, they know who they're talking to, which makes sense. It's a call center. But when we requested they delete it, they had to go delete that. So they couldn't be kind of merging that with other vendors or other customers of theirs where they had third party brought in. So it becomes a spider web of data dependency that we have to deal with. So updating those process vendor compliance, and then finally demonstrating that we have proper security. So building those risk assessments. There's also a new provision in the Virginia law that is if a consumer makes a request and the company does not reply or says they're not going to fulfill that request for one reason or another, then there's an appeals process. So this appeals process is new to Virginia, and that appeals process involves the organization. The consumer can appeal to the organization that, hey, you haven't given me my data. And the company says, well, we're not giving it to you because you're not in our system, right? And if they reject the consumer's appeal, they have to go back to the Attorney General and tell them why they rejected that appeal, right? Or they have to tell the consumer how you can go to the Attorney General and say, we rejected your appeal. So that's a new stipulation in Virginia law that never existed in California. So those are just some of the minor nuanced differences, but this is the overall process for what organizations need to do to get in compliance with privacy law. And of course, companies like captech and other companies are out there that can certainly help organizations do that. And there's a lot of software. And I actually wanted to take this moment to ask folks, how many of you all have worked on a privacy project, or your organization purchased a privacy software? I'd just be curious and to hear, what your experience was with that.
Hi, I'm Lori Radizak from the University of Pennsylvania, and I'm not familiar with everything the university is doing about privacy, but many years ago, there was the SPIA project, which I think focused mostly on social security numbers, but there was a big project to reduce the use of the social security number, and there's an ongoing process, I think, to monitor systems to make sure we don't use it. Otherwise, we're already subject to HIPAA and FERPA, so I think we've got a lot of privacy stuff already in place. For what
yeah, and those are some of the exemptions I was going to talk about. I'll talk about on the next slide. But Laura, that's great. Was there any the software that helped identify when social security numbers? Was that like a COTS package, or was that a custom solution?
I wasn't involved in the SPIA project university-wide, but part of the SPIA project was they installed something called Identity Finder on everybody's computers.
Yep.
And they had you run it on they ran it on a regular basis. And if it found any files on your personal computer that had anything that looked like a social security number, it would be flagged so that you could delete it. And in fact, the reason why the PEN ID is only 8 characters is because we did not want anyone to confuse it with the social security number. Plus, we didn't want this software to flag stuff.
Yeah, that's great. That's great. Yeah.
I've seen companies use TrustArc and OneTrust and other compliance tools.
Yeah, Eugene, thank you. Yeah, TrustArc and OneTrust. OneTrust is probably the leader in software solutions out there. A lot of our customers use OneTrust. It's in disclosure, we are a partner. We don't resell their software, but we partnered with them just because we wanted our consultants to come up to speed on OneTrust. But yeah, I mean, it is a really good full service privacy software. I don't have any problems with it. I think one of the problems with a lot of the software in the privacy space is they kind of came up out of nowhere. So you had a lot of the legacy vendors, Informatica and companies that did other things that kind of got into the privacy space. But then you had companies like OneTrust that came up and just built a platform to deal with privacy data. So because they were all so new, a lot of companies dealt with some of the pains of constant upgrade, updates on the software, things that the company expected the software to do that they had to do and customize. And so generally, I think there's a fair little level of frustration by organizations that were using privacy software because, let's be fair, it's a fairly new thing. And so, software that basically evolved over a 2-year span, there's going to be some kinks with it. But any other thoughts you had on that, Eugene?
And it's also elevated some existing tools like data catalogs because the first, there's different ways to do it, but you can have Privacy Finder look for it, or you can try to start documenting all the different places that your data exists and how to find it so that when you the delete request does come in, all the places to look.
Yeah, and organizations that have a high level of maturity with data management and data governance and even, you know, some master data management programs, they're in a much better position to respond to these privacy laws. So, you know, it just kind of goes to the importance of sound data governance, sound data management, because if you have those, you have proper metadata, you have effective lineage, you know, you have good data quality processes, you're going to have a lot, you know, it's going to be a lot faster to implement these changes. So let me jump on because I know I have a fair, oh, go ahead.
I wanted to throw in one more thing. Another thing that Identity Finder looked for was credit card numbers.
Yeah.
So it, you know, in terms of a tool that can work on a personal computer, I don't know what else it's capable of doing, but social security numbers and credit card numbers it can do.
Yeah, there's a software called Big ID out there. It's another good software package for privacy, and it does essentially like a crawl process, like you're describing, Lori, where it could crawl and look for PI data across the ecosystem of an organization. It was you know, it's a solution that a lot of my customers have looked at. Some of them move forward with the purchase of it, but it does provide that ability to sort of scan an organization's ecosystem looking for specific PI data. So let me jump to this next slide, slide 8, and I promise you I'm nearing the end. I know my time is clicking here. I want to say Virginia's law, I think I'm really proud of the law, even though, you know, last year, if you read a blog of mine I wrote, I was kind of a little weary of Virginia passing privacy law in at the beginning of last year in 2020, when they rushed to try to put a bill in. It actually, fortunately, got killed in committee because I don't think it was a very good bill. This law what caught a lot of us by surprise. We weren't expecting a law to be introduced in January about privacy, but it was. And even IAPP didn't even have this. They weren't even monitoring this. You know, they have this whole little website that monitors all the state legislation, International Association of Privacy Professionals website, but they didn't even have Virginia. They weren't even on the radar, right? And so Virginia brought this law to fruition in you know, just a month or so, and it's a really good law. It takes a lot of the good parts of the California law, and I think it takes away some of the really impediments to business. So it's a more business friendly privacy law. It shows the coalescing around privacy law. So Virginia takes some of the best of GDPR, of European law, like the risk assessments. It takes some of the best of the California law, the definition of PI data, some of the rights, and it's sort of taking all of that in, and yet it's still making it possible for businesses to do what they need to do. It's more business friendly. So the second point is it creates consumer rights, but does so in a business-friendly way. It removes potentially crippling right to private action, which we saw in California. It provides oversight with less onerous process, so the appeals go directly to the collectors before it's brought up to the AGs or the Attorney General. It increases the compliance requirements, collecting 100,000 versus 50,000 citizens' data. It carves out specific exemptions for data protected by federal law. This is going back to what you were talking about, Lori. So California did stipulate that HIPAA and Gramm-Leach-Bliley Act were exempt, but Virginia's went on to talk about FERPA, the Family Education Rights and Privacy Act that Lori was talking about, the Fair Credit Reporting Act, as well as the Driver License Protection Act. So if those laws stipulated information about privacy, it deferred to those laws. It said, you know, you're exempt if you're already processing with under those laws, but if you're not, then you need to comply with this law, the privacy law of Virginia. Additionally, controllers and processors that comply with verifiable parent consent requirements under the Children Online Privacy Protection Act shall be deemed compliant, and any parent consent obligations under CDPA are going to be obligated to that or subjugated to that. So it more clearly defines the sale of data, as I mentioned earlier, as the exchange of monetary, not other things. And it exempts publicly available data and broadens the definition to include what I call the social media exemption. So it broadens public information, people that put their information out in public. That is not considered PI data if it's made public by the consumer. And so I call that the social media exemption. That was not in California's law. So that, again, makes it a little more business friendly. If the data is out there, then companies don't have to consider this PI data if people put it out there on their own and they understand what they're doing. And finally, I think probably one of the most important things, and this goes to the federal law question that was asked earlier, Virginia's law unanimously passed, bipartisan. It was a bipartisan initiative. And it also happens, Virginia happens to be near the seat of our government in Washington. So a lot of the lawmakers and people working on Capitol Hill live in Virginia. So they're going to have an experience with Virginia's law. And so there's a good chance that a federal law, and most lawyers think a federal law will be passing in probably more likelihood under the current administration than the previous administration, which is going to be a little more consumer friendly, more than likely. And more than likely, it will look more like Virginia's law than California's law. And I think that's a good thing for the country. I think that's going to allow businesses to operate without huge penalties. And in fact, I think on my page a little earlier, I had a quote from Jeff Bezos from Amazon. Amazon actually, and big tech has gotten behind the Virginia law, unlike the California law, where they were really the target of the California law. They have actually said, hey, privacy is a good thing, but it has to be done in a way that businesses can still operate. And so anyway, that's my opinion. Again, clearly much of this is my opinion, but that I think is important. So what do you need to do? What to get your organization ready? What do you need to do? Well, there's sort of three paths. So the happy path is the companies that got compliant with Ccpra or were compliant with GDPR, and they have these automated systems that can go find PI data and can go provide, they have a website that consumers can make requests for their rights, and they have this fully automated processing. There's not going to be a whole lot you have to do. I'm estimating about a 1 to 2 month effort. You still have to modify things like your privacy strategy. You're going to have to build risk assessments. You're going to have to create a new risk assessment process that you never have had before. And you're going to have to add new rights fulfillments like the corrective action. You're going to have to modify potentially your opt-in for children, because that bar is actually lower for Virginia. So these are some things that organizations are going to have to think about. And this is why the push for federal law, because gosh, if an organization has to have one law for California and one law for Virginia, man, my governance has gotten much more challenging. My data management is more challenging because I have different laws. And that's why you're going to have businesses screaming for the federal government to pass a law. And both California and Virginia say, if a federal law is passed, that's going to be what we're going to follow, right? So 1 to 2 months to fix your systems if you're already Ccpra compliant. I said 2 to 4 months for companies that took a manual approach to Ccpra. That means they provided the privacy notice. They had the do not sell on their website, but behind the scenes, everything they were doing was manually. They get a letter and then they have to go run out and talk to John, Sally, and Josie about pulling this data and sending it to the consumer. And they have this manual approach. They have these like SWAT teams out there. We've worked with clients that do that go out and respond to these requests. They're going to have to do a little more. They're going to have to, again, deal with the risk assessment and the additional rights. But I think they're going to have to take a hard look at, hey, do we need to automate our approach? I think companies would be smart at this point to say, hey, it's in Virginia, but it's likely to come in Texas. It's likely to happen in New York. It's likely to happen in the state of Washington. And again, you can follow the state legislation options on IAPP. Obviously, California, Virginia, I think Nevada and Maine also passed laws that were much less stringent than California's or Virginia's. But so companies need to think about that. So I put a 2 to 4 month window at opportunities to get up to speed with companies that have a manual approach to Ccpra. And then finally, companies that didn't deal with CCPA, I think that's probably a 9 to 12 month window to get fully compliant and follow the processes that I described in the earlier slide. Any questions about this? Okay. Let's see, I am at time, but I did want to just quickly touch at marketing data deprecation. So one of the realities of new privacy law, browser restrictions, and walled gardens by a lot of the social media giants is that marketing departments are really hurting to be able to do what they do. And so they're the ones that are most likely impacted by privacy law. And so Forrester puts out this talk about marketing data deprecation and what you need to do about it. And basically what they postulate is that you should put together a customer intimacy framework that focuses on transparency and choice, the value of using and working with their data, with the consumer's data, and relationships with the consumer. And then finally, this last slide is let's turn privacy to a competitive advantage for us. So we as data professionals should be working with our organizations to say, let's not be reactive to the privacy laws. Let's make it a competitive advantage. And there's an ROI associated with doing privacy work that's really important, that you talk about the value of performing privacy work as a cost savings, as a revenue generator for the organization by avoiding significant costs like class action lawsuits or reputational risk or fines, or compulsory audits that happen if you have a failure, and measuring the impact on your consumers, if you have sort of this creepiness factor of collecting personal information and then trying to market directly to them because they're pregnant or they like weird shoes or whatever it is. You don't want that creepiness factor because there's a cost associated with that. And then avoiding having to pay third parties for, third-party cookies, for instance. Like if I have to pay for that, that's a cost. If I can avoid doing that because consumers are willing to give me their information because I have good privacy practices, there's value there. So talking about the ROI is really important. And then having greater transparency and better governance is critical, as I've mentioned throughout this presentation. So I know I'm at time, and I apologize, Eugene, for running a bit over. If there are any questions, I'm happy to answer it, but I know you have other guest speakers, so let me know what you want to do.
We have some time for questions. That was a couple that came in. That was a question about GDPR, and I mentioned penalties being the biggest difference, but if you wanted to add any others.
Can you repeat the question? I'm sorry, I didn't.
There was a difference as how the state laws compared to GDPR. And
yeah. So Virginia's uses a lot of the same language that GDPR uses. Talks about a processor and controller. So GDPR uses this language of who is the processor of data, who is the controller of data, and that's where the obligation is met. Both Virginia and California's law is different in that it provides a little more focused attention on the consumer and their rights. GDPR is more about making the organizations comply with the sort of standard of privacy, standard of consumer data. And if you've worked with GDPR, we worked with one of our international clients, things like where data was stored was important. So if you think about cloud, and moving to the cloud and massively parallel processing that might go across international waters, if you're storing consumer data like that, that would be a problem. That was a problem with GDPR. Like we had a client that used Salesforce, and they had a Salesforce instance in Europe, and they had a Salesforce instance in the US. They were trying to bring them together, but one of the realities was we weren't legally allowed to take the European customer data and bring it into the Salesforce instance in the US. So we actually, this is back several years ago, we worked with Salesforce to actually create sort of this walled cloud structure in Europe. So the cloud companies have gotten real good about this because they understood the ramifications of those laws. But that's a little bit about the differences. I mean, there's GDPR is much more extensive in terms of the language, the number of pages of content, and a lot more around the process of organizations taking proper care of data. So I think GDPR is, mandates that companies have good data management processes, whereas the US laws were more about what the consumer's rights were, and companies needed to, they didn't tell the companies how to do it, but they said you need to do a better job of data management and data governance.
Did anybody want to ask a question? You can unmute. Just
Pete, thanks for all the information. I thought this was great. The social media exemption, I think, is going to be a little bit more than a footnote.
Yeah, I agree.
So I'm curious your thoughts on that, and you kind of touched on it. Is there somewhere I can go to look up more detail on that?
Yeah, I can. Let me see if I've got a link. Actually, I'll send this. I'll put this in PDF, and you can look at it. If you follow up with Greg and get your email to Greg, I'm happy to send you some articles on it and some things that would probably help you get up to speed with it, because it's evolving, right? So a lot of this will play out in how judges interpret that, and how the Attorney General goes after companies that collect, scrape webs, social media sites for PI data and say, oh, well, it's, you made it publicly available, so therefore it's not PI data. I think there'll be a lot of kind of fine tuning in the courts about how that plays out. But yeah, there's some really, I actually was listening to a webcast the other day with two lawyers talking about this, and I can probably send you that link as well. Yeah, actually, OneTrust put that on, by the way, just as a plug for OneTrust. They put on a little panel discussion with some lawyers, and they had a big discussion about that issue.
That's funny. We are a recent OneTrust customer as well, so bringing them on board. And
you probably will get more from them. Talk to your OneTrust rep.
There you go. I'll do that. Well, again, thank you. I appreciate it.
Appreciate it, George. Thank you.
But it is, yeah, it is interesting, because some of the data is obtained outside of the consumer relationship, and in that case, does it have the same burden? Yeah, it's an interesting legal question.
Yes.
And if their data is incorrect on their social media site, do we get them to change it?
I can't imagine that would be defensible, that if you got it publicly outside of your consumer relationship. But I'm curious to see what the podcast says. I was going to ask about corrections to data that are not PII related. So, and it goes beyond, like you said, it's a broader definition of PII. It's obviously your social, but also the things you mentioned, plus biometric, and device IP, and just sniffing around your digital footprint on the, but corrections to data like your credit score or your propensity to return things, which are not PII, but they are, through the PII, you can identify the person, and then this data becomes available. How much data must be provided, and how much data must be corrected? Is it just limited to PII, or is it literally the entire master record at that point?
Yeah, so this is interesting, because a lot of financial companies have hidden under the fact that they're exempt because of Gramm-Leach-Bliley Act of providing, this PI data, and credit scores kind of fall into that, the Fair Credit Reporting Act. So I think there's some exemptions there, but we dealt with a lot of companies that had model inferences that scored customers by their behavior on the web. Like, so they would monitor their click stream analysis, and then they'd say, this is a frequent buyer or user of our product. This is an infrequent user, or somebody that we're not interested in marketing. And they had these designations in their model. They had a model score and they had a designation. And it wasn't very user friendly. I mean, it wasn't something you'd want to share with your consumer, with your customer. Right. And so companies, that one of our companies had to sort of change the way they summarized the personas, because those personas were a bit offensive. And it wasn't offensive. It made a lot of sense to the organization. It made a lot of sense to people working in the organization, but it would be offensive if a consumer was labeled as this persona. And so those personas were deemed as part of their PI by their own legal team. And so they changed those persona titles, but they still had to provide those personas to the consumers when they made those requests. So yeah.
Consumer segmentation is an interesting field, and I don't think most of the designers ever thought that this would be publicly available as a name, like a single child free, like in your mind that makes sense, but I don't think anybody ever thought this would have to be exposed to the world, and now it is a little bit embarrassing.
Yeah. And if they have that persona tied to an individual's unique record, then that is their PI data. Yeah.
Oh,
absolutely. So if they aggregate it and they just have general concepts, but obviously they're segmenting it to do specific marketing to that segment, which means they have to go back to an individual. So it has to be tied to an individual, right? But yeah, no, good. Fun stuff. So
yeah, I wanted to call a 5-minute break before our next speaker, who is here. And thank you for enlightening us with the latest and how to start responding.
Thank you, Eugene. Thank you, everybody.
The insights, and around 10:32, I guess we will kick it back off with the second speaker. So feel free to chat if you're not stepping away for a couple of minutes. I'll be going on mute myself. There are two of you.
Hey, Eugene.
Thank you for jumping on. Yeah, we just went over a good overview of the Virginia legislation that's coming up, and
Awesome. Yeah, that one's going to be a fun one for all of us, right?
speculated about what could happen at the federal level, if anything. Make it a little easier.
Wouldn't get our hopes up too high, though.
These things take time.
Exactly. There's a lot of other stuff going on right now at the federal level, so,
Right.
you know.
Yeah, and then it's, as a data organization that's been around for a very long time, we've gotten used to the idea of trying to convince others in the business side of things specifically, but other technical folks as well, that data is an asset. We have case studies that even tried to put it on the balance sheet, and this is now a case where data is also becoming a liability. If you have more data, then you have to worry about purging it and responding to these requests, showing people that the full depth of what you have about them was another topic that was covered. So it's an interesting balance now that you have to have a business purpose. You have to really rationalize storing things.
Yeah, absolutely. It'll be interesting to see what happens over the next, couple years.
Yeah.
Whether we're gonna have 10 state privacy laws or, one federal, maybe preemption, maybe not. It'll definitely be interesting to see. That's why I like being in privacy, it's always something new.
It's a growing field, and compliance in general has been a driver for a lot of the innovation and how best practices are put together.
Absolutely.
I mean, banking regulation, everything.
Right. Yeah, banking is a whole thing. They've been dealing with that kind of stuff for a while now.
Yeah, HIPAA was mentioned.
Yeah, GLBA, all of that. I think some of the rules around HIPAA are changing soon too.
Yeah. And one thing we didn't. Oh, really?
Yeah.
Huh. So, Lori, that's something to look forward to even more. Yeah, and then the one thing we didn't cover is that with all these states, and I've seen this too, and we talked about different tools people have used to comply, but also, there are companies that are national or international, and there are companies that are regional and maybe think that most of their consumers are not coming from that state. But and we didn't touch on this, but maybe I don't know if it's part of your presentation, but I've seen this struggle too. Is it's not easy for a company to ascertain definitively where the person is domesticated or has domicile or connection to. So if somebody says, well, I've spent some time in California, can you please delete my data? Err on the side of
Yeah, so I'll be talking about that when we get into the future proofing topic. So, the idea of offering the same privacy rights to everyone and how that could potentially be beneficial.
Yeah, it's a struggle that you may not even know.
Exactly. Yeah.
Where they are from.
Yeah, so offering it to everyone kind of takes care of that problem in a way.
Well, I think we're at 10:35, so I will let you kick it off.
Great.
So thank you for joining us. So just by way of real brief introduction, Donata is with Termageddon, LLC, which helps companies keep up with the latest legislation and decipher the different bills and find resources where, to keep track of this fast changing field. So Donata, please jump in and
awesome.
you are CIPP, and I'll make you a co-host.
Yes, I can share the screen because I do have a little presentation too.
A co-host, yep.
All right. So. All right. So hi, everybody. My name is Donata Strength-Gilbert, and I will be your presenter today. And thank you so much for joining today's session on how to keep up with and decipher privacy bills. So if you're just in the last session, you heard that 2 weeks ago, Virginia passed the Virginia Consumer Data Protection Act, and 15 other states have proposed their own privacy bills. So more and more states are proposing their own privacy bills, and that's a lot to keep track of. And today we'll discuss how to streamline that tracking so that you can save yourself some time and headache, hopefully. I would like to apologize in advance. I have 2 very big dogs who like to bark. So if you hear that in the background, I'm sorry. And while I am presenting, I can't see the chat. So we'll check the chat after I'm done with the presentation, and then we'll have some time to answer questions. And then also, if you have any questions that you think of after the presentation, I'll put my email in the chat so you can reach me that way as well. All right, so before we start, let me tell you a little bit about myself. So I'm an attorney licensed in Illinois, and I'm a certified information privacy professional. And that certification comes from the International Association of Privacy Professionals. And I've been working in privacy and technology law for about 5 years now. And I'm the president and legal engineer behind Termageddon, which is a software as a service company that has generated thousands of privacy policies and kept them up to date with changing privacy legislation. So tracking privacy legislation is a huge part of my job, as well as interpreting current privacy laws, regulations, and all of those changes. I'm also the vice chair of the American Bar Association's e-privacy committee and the chair of the Chicago chapter of the International Association of Privacy Professionals. Being a lawyer, I wanted to note that this presentation is provided to you for informational purposes only, and I'm not providing any legal advice. So you should make sure to contact your own attorney or find an attorney to kind of implement all of the things that we're talking about. All right, so today we're going to discuss a couple things. So why it's important to keep up with privacy bill proposals, resources and tools that you can use to keep up to date with privacy bills, how to decipher a proposed privacy bill or new privacy law if that lands on your desk, future-proofing your design and development so that new privacy laws have the least amount of impact on your organization possible, and then how to choose privacy-focused vendors and tools. Because as you learned today, it's going to be really difficult to keep track of all of this by yourself. You're gonna want to use some tools, use some resources to kind of help you along this journey. Because as a full-time privacy lawyer, I can say that probably about 50% of my day has been taken up by tracking a lot of this stuff. So you're gonna wanna make sure to streamline all of this, and that's what we'll discuss. All right, so let's talk about why it's important to keep up with privacy bill proposals. And I'm going to take you down a very quick trip down memory lane to 2018. So 2018 was really a pivotal year for privacy because of 2 events. So first, the General Data Protection Regulation, or GDPR, went into effect in the European Union. That's the privacy law that protects the personal data of European Union residents. And 2, the Cambridge Analytica scandal broke. And most of you are probably aware of the scandal, but if you're not, here's a quick overview. In 2018, the story broke that the firm Cambridge Analytica scraped the data off of millions of Facebook users without permission, and then used that data for political advertisement and targeting for those advertisements. And one thing that not a lot of people know about this event are actually the consequences of this event. And it's really changed privacy, right? If you think about privacy 5 years ago, those of you that are in healthcare, those of you that are in banking or financial compliance, obviously you know that privacy was a big deal. But all the rest of you in the different industries, privacy wasn't really a big deal before then. Consumers didn't really, they kind of cared about it, but not enough to actually do anything about it, not enough to speak up about it, not enough to check if your website has a privacy policy. And since 2018, that's really changed. So basically, the event shocked many consumers in the sense that it exposed the dangers of sharing their personal information online. So because of that, consumers are pressuring their state legislators to pass privacy laws that would prevent companies from abusing the privacy of consumers. So a great example is a study by KPMG, which said that 84% of respondents stated that they are open to new privacy laws. That's a lot. That's a lot of respondents who even knew what privacy laws were and also wanted more of these. So I think that's very interesting to bring up. And that brings us to our next issue, which was kind of discussed in the last session as well. So in the United States, there is no federal privacy law that applies to the collection of PII by websites and online platforms. On the other hand, you have the European Union, which has one set of rules, GDPR, but in the US, we have states proposing and passing their own privacy bills. So right now we have about 14 states that have proposed bills, meaning that the state patchwork is growing increasingly complex and it's not going away anytime soon. So you really need to pay attention to these requirements. The state patchwork is the new normal. I know that some of us kind of cringe when seeing that phrase, the new normal, because it's just so tied to COVID. But the state patchwork is the new normal. It's what's going on. And until we see some movement on the federal level, we're not going to see it go away. And consumers want privacy protections now, and they're really, that could cost your business. So according to an Axios study, 93% of Americans would switch to a company that prioritizes data privacy. So keeping track of privacy developments and providing consumers with privacy protections could be good for your business as well. So it's not just managing risk and managing compliance and complying with the requirements and avoiding fines and potential lawsuits. It's also making sure that your customers feel like they're heard and making sure that you don't lose those customers just because you couldn't be bothered to care about privacy. All right, now, so as we just discussed, there's a lot going on in privacy right now. There's a lot of states proposing and passing their own privacy bills. If you don't have a clear strategy for keeping up to date, or if you're not using the right resources and tools, staying up to date can be really time consuming. So let's take a quick look at what staying up to date will look like without the help of tools. And then we're going to take a look at what staying up to date looks like if you do have the right tools. So if you want to do this on your own, here's what you're going to have to do to keep track of these bills. So first, you're going to have to visit the websites of each of the state's legislators. Then you're going to need to figure out how you can set up alerts on those websites so that you get an email when a new bill is passed. You might be able to set up alerts for topics that you're interested in, such as privacy, or you might just have to receive all of the alerts on all of the bills and then sort through. And then lastly, you're going to need to sift through the email alerts to sort out the bills that you actually want to know about. And then you'll need to read each of the bills for their main points. And we'll talk about how to do that shortly. So for my job, I could track of privacy bills, and I can tell you this would be a very, very time consuming thing, leaving you about 10% of your time to spend on your actual job. So if your job is not tracking privacy bills, you're going to spend 90% of your day tracking privacy bills and 10% doing your actual job, which, if you have a manager, they're probably not going to be super happy about that. So it's a very time-intensive way of doing this task, and it'll leave you very little time to do your actual job. So my recommendation is to use tools and resources to save yourself a lot of that time and headache. So next, let's talk about some tools. So when it comes to choosing a tool and having a tool that can help you keep track of privacy bills, there's a couple questions that I think you should ask yourself first. So first, who's keeping the tracker up to date? So make sure that you're only using reputable sources. Some trackers will send you alerts on bills only, and then it's up to you to review each bill and put it into the tracker, while others will put the tracker together for you. So they will actually list the salient points of each bill, and you can kind of have a quick glance. Okay, these are the states that have proposed it. These are the rights that they provide to consumers. And this is what this looks like. And I'll show you actually a couple of these trackers in just a minute. Next, when is the last time that the tracker was updated? So there's a lot going on in privacy, and there's a lot changing all of the time. So if you see a tracker that was last updated in 2020, or maybe a tracker that was last updated a month ago, that tracker is out of date and can't be trusted. That's especially true when legislators are in session. So when legislators are in session, the tracker should be updated at least once per month or more frequently. When they're out of session, the tracker will be updated less, obviously. When you search for a tracker online, and I'll give you some examples of trackers so you don't have to kind of mind Google for this answer, but if you look for a tracker online, usually the tracker will say, it'll come in like an article or a PDF, and it'll say last updated date. And that's the date that you need to pay attention to. One thing that I would like to caution you against, and this is very not intuitive, a lot of law firms have trackers, and pretty much all of the trackers that are kept by law firms are going to be out of date, unfortunately. It seems like some associate comes in and they're assigned the job of putting together this tracker, and then they move on to like real cases and real work, and then the tracker is just left there to kind of stay, and nobody updates it until the next associate or intern comes in. So be careful about using law firm trackers, but the best way to tell how accurate the tracker is when's the last time that it was updated. So watch out for that date. And then lastly, you'll want to figure out whether the tool analyzes the bill and gives you the breakdown of the most important components, or if you had to do that yourself. So, that can take a lot of time, reading each bill, figuring out the main components, figuring out what the requirements are, who it applies to. So usually tools that break down each bill are probably a little bit more accessible, will save you more time, but you still have to trust that what they say about this bill is correct and accurate. Now, one item that I didn't put in here is cost. Obviously, people who or companies that have limited budgets are not going to want to spend a ton of money on this. I didn't really focus so much on that issue in this presentation because one of these tools is paid, but the other two are free. But that's something else to keep in mind is the cost. So let's talk about some of the tools that are available. So first, you have LexisNexis StateNet. That is a tool that I personally use to keep track of bills, but it is more time intensive than others, and I'll kind of explain why. So basically, LexisNexis StateNet allows you to set up alerts according to certain search terms. So for example, privacy policy, privacy notice, or privacy, and then it'll send you an email alert when a bill has been proposed that includes those terms, right? So any lawyers on this call are probably familiar with LexisNexis. Westlaw has a similar type of service, I believe. And LexisNexis is basically like Google for lawyers. So you can set up alerts on certain terms that you're interested in. If you're interested in other laws such as HIPAA or Ccpra or something like that, I would use the LexisNexis regular platform that will tell you about cases. So you can set up alerts on certain topics if you're interested in cases about those laws. LexisNexis StateNet is specifically for proposed privacy bills. So it's not really for existing privacy laws, it's just for proposed privacy bills and what has been proposed. Now, you will get those alerts. You'll still have to sort through the alerts. It's relatively accurate, but every once in a while you get something that's not accurate. So you'll have to sort through that. And then you'll also have to put that in your own tracker, kind of breaking down each bill. Now, LexisNexis StateNet is a bit pricey. I pay around $1,000 per month. And again, you'll have to read each bill to learn its requirements, but it's definitely a favorite tool of lawyers. And it's great if you do not want to rely on others to make sure that they track these bills properly. So next we have the International Association of Privacy Professionals State Comprehensive Privacy Law Comparison. The IAPP is an awesome organization, and they provide a free tool that lists all of the proposed bills and the important parts of this bill. I use this tool myself, and I like it a lot, but you have to be a bit careful because every once in a while, they don't update the tracker right away. So let's say Florida proposes a privacy bill today. Usually you'll see it on the IAPP State Comprehensive Privacy Law Comparison in about a week or two. Sometimes less, sometimes a little bit more, but it's a really great overview. It's a really great free tool, and it's a really great way to kind of check what's going on. And then lastly, we have the Termageddon Privacy Bill Tracker. This tool is available at termageddon.com in the blog, and it's also free. fair warning, I created this tracker myself and keep it up to date myself. So I keep it up to date whenever LexisNexis sends me an alert, or whenever I see a new privacy bill being listed on the IPP, or whenever I get an alert from the state body that they've created a new bill. And sometimes I will update this thing multiple times per day. And I also break down the important points of each bill. So let's kind of see what these look like. So this slide just shows you what the IAPP and termageddon trackers look like. You'll see that each tracker breaks down the consumer rights provided by each bill and lists the business obligations as well. And honestly, if I were to give you any advice, is to use both. It's a great way to make sure that everything's up to date and that you don't miss anything. You can see the IAPP comparison includes past bills, termageddon does not, or the IAPP includes failed bills or some failed bills, and I don't do that. I just include the bills that are in play right now. And actually, the screenshot is out of date because I took the screenshot about a week before the presentation when I was putting together my slides. And since that, West Virginia has proposed its own privacy bill. So that kind of just illustrates to you once again how quickly things can change. But if you go to termageddon.com, if you go on the blog and search privacy bill tracker, you will see the most up-to-date version of this tracker. So basically that's what these look like. So instead of having to go through each state's website and figure out how to set up alerts and sort through, hundreds, if not thousands of emails, you can just go into these tools and take a look, have a quick overview of what's going on. Because for a lot of you, the real work starts when the bill is passed. So, you probably don't want to spend hours and hours and hours of time on tracking these because a lot of these won't pass. So, it really becomes important when it moves closer to that passage, when it moves closer to the effective date. But this is a great way to keep track of what's actually going on and what's out there. And what I think is really interesting and cool, and you'll kind of see this too, as you track these more, you'll start seeing certain patterns. Great example, all of these bills require privacy policy updates. Some of these bills exempt small businesses, some don't. These are the rights that are usually provided. These are the obligations that you're usually under. So you'll start seeing these patterns as time goes on, and these trackers will help you see those patterns as well. All right, so now that you know about some good tools, let's talk about deciphering the bills or privacy law that's just passed, right? So you're looking at these privacy bills, or you're looking at Virginia's new privacy law. It lands on your desk. Somebody says, hey, what does this mean? Or, hey, what do we need to do? Or how do we need to prepare for this? And you will need to decipher a proposed privacy bill or an existing privacy law. So I'll kind of talk about some important points that you'll need to pay attention to when deciphering. I'm just gonna have a quick drink of water. All right. So here are the important points that you will need to think about. So first, how does the bill define personal information? So some bills provide a broad definition of any information that could or does identify an individual, while others provide a more narrow definition, such as username and password. And determining how the bill defines personal information will help you figure out whether that bill applies to you. So if you're not collecting any information that qualifies as personal information under the bill or the law, you don't need to worry about it and you can just stop reading. But if you do, then you need to continue reading it. Second, who does the bill apply to? So some bills apply to any business that collects the personal information of residents of that state, while others have specific factors that you need to meet, such as revenue thresholds, the amount of personal information that you collect, or the percentage of revenue that you make through the sale of personal information. Now, obviously, if you don't meet that criteria, then the bill wouldn't apply to you and you can move on. But if you do, then you need to keep reading. So you also need to pay attention to the privacy policy requirement. All proposed privacy bills require websites to have a privacy policy that makes some very specific disclosures. So you need to see if your current privacy policy has those disclosures or if you'll need to update it. And we'll kind of talk about how to future-proof your privacy policy in a minute as well. security requirements. I know this one's important to a lot of you. So some bills may require you to establish adequate security requirements to protect personal information. So make sure that you're on the lookout for that. And then some privacy bills allow consumers to opt out of automated decision-making and profiling. That's something to keep an eye out for if your organization undertakes such activities. And then lastly, privacy bills provide certain privacy rights to consumers. So such as the right to access, correct, delete, opt out, withdraw consent, portability, and non-discrimination. These rights are very important to know as they will affect your operations and require you to develop procedures and systems that will allow you to properly respond to consumer requests to exercise their privacy rights. So on the next slide, we'll talk about what those rights actually are. So the point of privacy bills is to provide certain privacy rights to consumers. And kind of goes regardless of whether or not those consumers exercise those rights or want to exercise those rights. As consumers become more educated about those rights, you'll see more consumers exercising them as well. So let's kind of run through what these rights are. And you'll see these in almost every bill in some shape or form. So some bills provide the right to delete, others provide the right to access, others provide all of these. So those are kind of, you'll see that in the privacy bills. So the right to access, the consumer has the right to know whether you hold their personal information and what information you actually hold about them. They might also have the right to know some ancillary information as well. So like, what do you do with that information? Do you share it? Do you sell it? Stuff like that. Right to portability, the consumer has the right to receive the personal information that you hold about them in a structured, commonly used, and machine readable format, and have the right to transmit that information to another entity. That's going to be a very interesting challenge for a lot of companies that don't currently offer this right. Right to delete, the consumer has the right to have you delete the personal information that you hold about them. Right to correct, they can ask you to correct any incorrect personal information or complete any incomplete personal information that you have about them. Right to restrict processing, the consumer can specify they can use their personal information for some purposes, but not for others. So for example, if I purchase a pair of shoes online, I can tell you, okay, you can use my information to ship me the shoes, but you can't use it to market to me or send emails to me about other shoes that I might want to buy. And the right to opt out, consumers can opt out of the sale of their personal information. Some privacy laws allow them to opt out or withdraw their consent from processing information in general. And then opt-in consent, which is very popular in Europe, but not so much in the US. You're required to get consent before you can collect or process their personal information. Now, two things that I did want to note here. One, these rights are not necessarily absolute. So there are certain instances in which you could potentially tell the consumer, I'm sorry, but we can't delete your personal information. And then what's really important to remember about these rights is that all of these rights require you to know where you keep personal information and who that personal information has been shared with. So I think that kind of brings us into our next set of tips here. So tips for data discovery. So let's say a customer contacts you and says, okay, I want to know what personal information you have about me. If you don't know where your data is, there's no way that you're going to be able to satisfy that request. And that can leave you open to fines, and that will leave you out of compliance. So as we see more and more of these privacy bills pass, let's say you don't have any privacy laws that apply to you right now, or you have some very minor ones that apply to you right now. This is the time to start working on data discovery if you haven't, because as these laws pass, data discovery is going to become more and more and more important, because these privacy laws have a certain time limit for when you can respond to the consumer. And, some have 30 days, some have, longer. But if you have 30 days to respond to a consumer request, that's not the time to start discovering where your data is. You should already know where it is when that request comes in, because if you don't, you're going to miss things. You're going to fail to delete all of their information. You're going to fail to give them access to all of their information, and that's going to get you into trouble. So data discovery is crucial for the exercise of privacy rights. And here's some tips. So first, plan ahead, determine why you're undertaking this task. Are you undertaking it for compliance with privacy laws, or are you trying to meet a specific standard such as ISO 27001, or are you doing it for operational improvements? How are you undertaking this task? Make sure that you create the relevant policies and procedures at the start so that the same steps are repeated and everyone knows how this task will be achieved. And that will actually lead to less errors, because if you're applying different sets of standards throughout your data discovery, it's not going to work. You're just not going to get to where you need to be, and it's going to just become a jumbled mess. So make sure you plan ahead. Know who's responsible for completing this task. Make sure that you assign it to a team lead if you have a whole team that's working on this, or make sure that you assign this to a person if you just have one person in your organization working on this, so that there's accountability. Automate data discovery and classification. So as you know from the first part, I'm a huge fan of tools that help me save time. And manually classifying data is extremely time intensive, and the process can be prone to errors. All of us are humans here, all humans make errors. So look for a solution that supports multiple methods for classification, such as catalog-based search, regular expression, and patterns, as well as the ability to search data directly within a table. That's definitely going to help you. 3, use machine learning and AI. Make sure that you're using the best tools, the most up-to-date tools, the most cutting-edge tools if you can. And lastly, make sure that you're picking the right tools. So make sure that any tools they use that have access to your customers' personal information are privacy focused and compliant. And we'll discuss this portion in a few minutes as well. All right, so let's talk about future proofing. And this is one of my favorite topics. So how can you set yourself up so that new privacy laws have the least possible amount of impact on your organization? How does that work? So as we saw earlier, there are a ton of new proposed privacy bills, and more states are passing their own privacy laws. So you need to come up with a strategy now to future-proof your design, your organization, your privacy practices, so that there's the least amount of impact on your organization when new privacy laws are passed. So here's a couple of my favorite ways. So first, follow the most stringent requirements that you're subject to, and apply those stringent requirements for all of the personal information that you hold. It's way easier than having multiple sets of standards. So don't separate data into GDPR or CalOPA. Pick the most stringent requirement and apply it to all of the information that you hold, and that's going to save you a lot of time and effort. Second, as we discussed, residents of certain states have robust privacy rights. Others have less, others have no privacy rights. So instead of providing privacy rights to everyone, instead of providing privacy rights to people based on their location, consider providing privacy rights to everyone regardless of their location or their place of residence. So this will actually reduce operational costs associated with confirming residency, and will help your company demonstrate its commitment to privacy, and will reduce the number of updates that you need to make as states provide more rights. So every time that a certain state provides certain rights, you have to update your privacy policy if you're doing it by state or by residency. And if you provide those rights to everyone, you don't have to update anything. It's just already in there. Everyone gets the same rights, and then you're done. Lastly, avoid having multiple privacy policies. I see a lot of companies providing one privacy policy to residents of California and another one for everyone else. So this is a strategy that kind of works right now. There's only a few privacy laws, but if we have 5 or 10 states with their own privacy laws, it's not going to work. You're not going to have 5 to 10 different privacy policies. And the thing too is, as new regulations pass, you're going to have to update those all the time. And as your privacy practices change, you're going to have to update those policies, each one. So like 5 to 10 privacy policies, you're going to have to update each one if you change, one thing about your privacy practices. So it's something that's not going to be sustainable, for much longer. So what I would suggest is have one privacy policy that includes all of the rights, that includes all of the requirements, so that you don't have to update 5 to 10 different documents. All right, the other thing that you can do to prepare for the future is to follow privacy by design principles. So privacy by design calls for privacy to be taken into account throughout the whole engineering process. And I really won't go through this at length because we don't have that much time, but I did want to mention a few of the most important elements of privacy by design. So first, proactive, not reactive, preventative, not remedial. This means that you should anticipate and prevent privacy violations before they happen. Privacy is the default setting. No action should be required on the part of the individual to protect their privacy. It should be protected by default. Facebook is really bad at this. The default settings are a nightmare for privacy, whereas really the default settings should be protection of privacy, and then you should be able to choose if you want less privacy. Privacy embedded into design. So privacy should be an essential component of the core functionality being delivered, not an add-on after the fact. And full functionality, positive sum. Privacy by design avoids the pretense of false dichotomies, showing that you can have both security and privacy. So you can have both, not either. Full lifecycle protection. Privacy by design ensures cradle to grave, secure lifecycle management of information end to end. Visibility and transparency. Make sure that you're transparent with your customers about your privacy practices. You'll see some great examples of this in a minute. And then respect user privacy. Offer measures such as strong privacy defaults, appropriate notice, and empower user-friendly options. So let's take a look at some examples of what not to do when it comes to privacy by design and when it comes to future-proofing. So a couple of examples here of privacy practices that will probably not stand the test of time. So first, on the left-hand side, you'll see Allergan has a California privacy policy that says, if you're not a California consumer, this policy does not apply to you. Instead, please refer to our United States website privacy statement. First, California is part of the United States. So if a customer goes onto the website and sees United States website privacy statement and then a California privacy statement, that's going to be a little bit confusing because United States and California is part of the United States. But as more privacy laws are passed, this practice will become unsustainable and become more and more confusing to consumers if you have 15 different privacy policies. In the second example of a different privacy policy, we see a list of privacy rights, and it's very unclear as to who those privacy rights actually apply to. It says depending on your location, such as the EEA, Canada, California, and Nevada, you might have certain additional rights, such as, but it doesn't say like who actually gets those rights. So providing the same rights to everyone will help you comply with the existing privacy laws. It will be less confusing to consumers, and it will actually help you prepare for future privacy bills as well. I think this is actually from Lulu's, which is a clothing site. So there you have it. All right, second set of examples on the left-hand side, you'll see a cookie solution. This is really an area where I'd love to see some privacy by design. If you're subject to GDPR and the e-privacy directive, you need to get consent for the collection of personal information if you have non-essential cookies enabled on your website. Consent means the ability to say yes or no, or accept or deny. Both options need to be available to the consumer. As you can see here, the options are accept cookies and manage preferences. So you're not actually getting proper consent, which means that you're not going to be compliant. And then in the second example, you can see a checkbox to agree to terms of service. If I click, I have read and understood the terms and conditions, and then I click more info, it'll actually tell me that, my email is going to be used for marketing, both from this company and from their carefully selected partners. So you're really not getting consent here. It's clear that this is a great example of dark patterns to essentially almost like fool the customer into agreeing to things that they didn't know that they agreed to. So those types of practices are really not going to fly, whether right now or in the future. So definitely try to avoid those. All right, so let's talk about good practices. So on the left-hand side, you'll see a screenshot of a privacy policy. This privacy policy lists all of the rights clearly, and it says that these rights apply to everyone. So that will actually help protect you in terms of, complying with existing privacy laws. It's not confusing to consumers. It's very clear. Everyone has the same privacy rights, and that's going to, future-proof your design in the future as well. And then in the second example, you'll see that the company has a privacy center on their website where individuals can update their settings and even exercise their privacy rights without ever having to contact the company. So the ability to automate some of these requests will definitely save you time and allow your customers to have a less frustrating experience when it comes to their privacy rights. So I really like this. I think this one is provided by a company called DataShips. All right, and then more examples of good practices. On the left-hand side, you'll see there's a footer of a website where the privacy policy can easily be found. So make sure that your website does not hide the privacy policy. Too many websites have the link one shade lighter or darker than the background or in tiny text so that it's basically impossible to see and find. And multiple privacy laws actually have standards of how your privacy policy needs to be displayed. So make sure that you're following those standards. And then lastly, we have an example of a contact form with a checkbox to agree to a privacy policy. So make sure that your checkboxes are not pre-checked. If there are pre-checked, then you're not showing good consent, and you probably can't process that data if you're subject to certain privacy laws that require consent. And make sure that consumers have clear access to the privacy policy and can easily see it. All right. And now we're going to go on to our final topic of choosing the right vendors. So this topic is very important as several privacy laws require you to be diligent in your vendor selection. So for example, if you're subject to the Ccpra and the Ccpra and share personal information with a vendor, you are required to enter into a contract with a vendor that specifies the personal information is used and that it is used for specific purposes only. And I know that's something that was touched on in the last session. Obligates the vendor to comply with the Ccpra and Ccpra, grants you the right to verify that all of the requirements are being followed, requires the vendor to notify you if they cannot meet their obligations, and grants you the right to stop sharing personal information with the vendor if they cannot meet their obligations. So when choosing a vendor, you have to make sure that you choose a privacy-focused vendor, especially if you're sharing your customers' personal information with them. So there are a couple items that I would suggest doing if you are evaluating vendors. So first, does the vendor have an up-to-date privacy policy? Usually when you go onto the privacy policy page, it will tell you when it was last updated. If it was last updated like 2, 3, 4 years ago, it's not up to date, and that's probably not the right vendor for you. 2, does the vendor use non-compliant data transfer mechanisms such as the EU-US Privacy Shield? The Schrems 2 case struck down the EU-US Privacy Shield, and it's no longer a viable method of transferring data from the EU to the US. So if your vendor is using that as their transfer mechanism, and usually they'll list it in the privacy policy if they do, that vendor's not compliant, so you don't want to do business with them. What privacy laws is the vendor subject to? Ccpra and Ccpra, GDPR, CalOPA, all of that stuff. Are they subject to the same privacy laws that you are? Do they have the proper disclosures? Do they follow the right things? Is the vendor willing to sign a data processing agreement? So that's actually going to be very important to you if you are needing to comply with GDPR. You need to make sure that your vendor is following certain standards. If the vendor is not willing to sign a DPA, not willing to sign an NDA, not willing to sign any contracts, that's a red flag usually. I would also contact their privacy department with a simple question. Usually the privacy policy will provide the contact information for the privacy department and see how long it takes for them to respond, right? Contact them as a regular customer, because if you get a request to delete data and you need to ask your vendor to delete that data as well, you need to make sure that they're responding to you within a good period of time so that you have enough time to respond to your customers as well with their requests. So just contact them, see how long it takes for them to respond, if they respond. Search reviews. Reviews will often tell you what kind of company that is. Now, some people leave reviews only when they're angry. So if you see like 1 or 2 bad reviews, that's not something to be concerned about. But if you go to their Better Business Bureau profile and there's been 1,000 complaints that have been filed against the company, that's a red flag. And then search company name and lawsuits. So put that into Google. You will be surprised what you can find. I remember I was once doing due diligence on a vendor that provided shredding, right? I believe it was Shredded, but don't quote me on that. So I searched the company name and lawsuit, and I found out that they were sued because they said that they were shredding all these documents. And it turns out that they were actually dumping the documents in public trash cans in like public parks, and people found those documents and read them. So if you're searching for a vendor to shred your documents and they've been sued, successfully sued for dumping documents in a public park without them being shredded, that's probably not the right vendor for you. So that's something to keep in mind as well. And then does the vendor use the same tools or solutions as you do? So do they use TrustArc or OneTrust if those are the vendors that you use? It's going to be generally a lot easier to integrate with a vendor and to work with a vendor if you're using the same trusted tools. So that's something to keep in mind when choosing the right vendors. All right, so I know I just went through a lot of information, but we kind of covered why you should keep track of privacy bills, how to do it, how to choose vendors, how to future-proof your design, things that you should be doing and things that you shouldn't be doing. And here's my email as well, so I'll leave this up here for a minute, so you can shoot me an email if you have a question afterwards too. And I guess, Eugene, we'll probably see if there's any questions from the audience.
Yeah, please, by all means. Yeah.
Awesome. I know we just have a couple minutes, so if anybody has any questions, feel free to put them here. I'll stop sharing my screen, and I will also put my email in the chat too. All right, so it doesn't look like we have any questions. It must have covered everything with perfect clarity.
You did well.
Yeah.
Awesome.
Yeah, I'm just trying to. I realized that for our third speaker, so I had the restrictions for the country set up, and he's having trouble joining as a result. So I apologize. I'm multitasking, but
no worries at all.
No, but thank you. I wanted to ask if there are no further questions, if folks wouldn't mind if I restarted the meeting. I have to change the setting. I have to restart the meeting. If folks wouldn't mind rejoining in 5 minutes or so with the same link. But give me a second. Let me see if I can save us from having to do that.
Well, thank you everybody so much for coming to this session. I really appreciate it.
Yeah, it's really important to stay on top of these things. It seems like there's no shortage of activity to track these days. So it's
oh yeah.
I know we're all trying to do the same. So
exactly.
Thank you for giving us the tools. So I'm going to say 11:25 and just use the same link. And I'm going to end the meeting and then let everybody back in, if that's all right.
Okay, see you soon.
See ya. Bye.
Okay. All right. Thank you.